A probation violation turns courtroom tension into a ticking time bomb. Hundreds of emails, a frightened victim, and a defendant fighting for mercy. This hearing is a high-stakes clash of law, fear, and accountability.
Court does call the case of People versus Vijay Dandamudi.
Calvin Hawthorne for the people.
Good afternoon. Attorney Matt Hauser here on behalf of Mr. Dandamudi.
You're going to need to get to the other side. Which side? There you go. Counsel, this is an allegation of, he's on probation to this court. There's an allegation of violation of no contact order with Ms. Hodge. It says here numerous emails sent, according to the report that I saw, somewhere in excess of 300. Go ahead, counsel.
Yes, Your Honor. So last week, Agent, I forget my pronunciation, I believe it is
Pilara.
I'm sorry, yes, Agent Pilara and myself, I did have various correspondence back and forth. She did send me a copy. I'm not sure if it was all of the emails, but it was a very healthy sampling of the emails, in addition to the police report that she does make mention of in her recommendation, that being report number 25-44520. Also, then Friday afternoon, after I had received her recommendation, I did provide the treatment documents that her and I discussed previously that were provided by my client's father, Dr. Dandamudi, who joins us here in the courtroom today. And if there are any questions as it relates to Mr. Vijay Dandamuni's ongoing treatment, I would defer to Dr. Dandamudi as he can opine on those much greater than I. I guess with that being said, I have not had the opportunity to speak with probation since those treatment documents have been provided. So I'm not sure if that would impact the recommendation that has been made. Nevertheless, as it relates to the underlining violation that we're here for today, in a pre-hearing discussion with my client, we would be willing to stipulate to the violation that occurred, and then of course would ask to be heard as it relates to sentence.
All right. So he's admitting to the violations.
Yes, Your Honor.
All right. Very good. All right. As to sentencing, and counsel, I will leave it to you. We did not expect that. When did you send the treatment information?
It was Friday. I want to say Friday afternoon. So it was late. It was late in the day, and this was also on the same time that I found out the court date was today, opposed to Wednesday morning. So last week was a busy week.
Yes. I will leave it to you. Certainly, I did not get an opportunity to look at any treatment information. And if you'd like the court to take that into consideration, certainly I would put this over so that could occur. If you think that treatment information is going to be something that the court should take into account.
I guess I would say yes, Your Honor. I mean, as the court is aware, this case has been ongoing for some time. And while Mr. Dandamudi is of course sorry that this relapse occurred, with the treatment plan that has been in place, we have been successful in not having this type of contact for quite some time. While yes, the bump in the road, we think a review of the treatment material and the ongoing plan may help sway what a final sentence would be in this case. With that that being said, we fully understand there will be some amount of jail to be served based off the comments of Your Honor from the last time we were here. The request is going to be that that if there is jail to be served, which we believe there will be, it be for a period less than the year that has been recommended by probation.
Well, I will certainly, I mean, there are a lot of unforeseen circumstances, including Ms. Valera's absence, so I will certainly adjourn it. I will say this, since he's admitted to the violation, I have looked at, to the extent one could stomach it, the emails that were sent to Massage, and maybe something at the next year you're going to certainly have to convince the court of is that I just don't, this is not a bump in the road. And if it's a bump in the road, then somehow or another we need to take a new path, because she should not have to deal with this. And let me just say also, as the court was thinking this through, certainly, she's having to deal with it almost in a fact where she doesn't know, and then all of a sudden it happens, which has got to be absolutely terrifying, because you just don't know if the next day it's going to be this, the next day it's going to be that, or if he's out, if he's going to, God forbid, follow through with his what some may call an ideation, but with clearly, I think, and I don't think I'd be overestimating it from Mrs. Hodge's perspective, just out and out threats to her and her well-being. And so I will certainly, in the point of fairness, I know Ms. Hodge would probably like for this to be over, but to be fair, I will give you a new date to come back, and we will deal with it, but the defendant is going to be remaining in custody without bond pending that next day. Counsel, my next date is actually October 20th, so it's a month out.
Okay.
Because of the, I think you may have heard it on the other case, because of time off and then vacation.
Oh, yes, Ron. And just so the court's aware, there also is a sentencing date for the circuit court on November 5th as well.
Okay.
The circuit court case.
That means, so I will adjourn the sentencing on this to October 20th, 2025, 1 p.m.
Thank you, Your Honor.
Thank you.
We'll see you then.
He is out of the courtroom. Thank you, Ms. Hodge, for attending. I do appreciate it.
Thank you, Your Honor.
Okay. That's it for me.
Justice balances accountability with caution. Breaking the law isn't just a mistake. It's a risk to others and to your own freedom. Courts will give time for rehabilitation, but repeated violations carry heavy consequences.